Thank you, Kim, for that kind introduction. Hey, Chip Cooper, Internet Attorney for FTCGuardian.com, #1 in FTC compliance training. Now, in this short video, I'd like to explain the bonus that I'm providing for Engage Pro Level members and up. This bonus is a basic level membership in FTC Guardian, and I'd like to explain the benefits of your basic level membership. Then second, I'd like to explain your upgrade rights. As a basic level member, you have the right to upgrade to the pro level membership, and I'd like to give you a little bit of a description and an idea of what you can expect when you upgrade. And then finally, I'd like to provide some real training for you right now that you can probably use immediately, certainly if you're engaged or plan to be engaged very soon in what I think is the next big thing on the internet, retargeted and targeted ads. So we'll finish with some training about 3 killer mistakes that you definitely want to avoid with targeted and retargeted ads. But first, what about the bonus that Kim is making available to Engage Pro level members and up, which of course is the basic level membership in FTC Guardian? This level of membership consists of 8 documents, which I believe almost every online business or marketer would need in order to begin with FTC compliance. Now, we start with what I call the big 3, the legal page, terms of use, and privacy policy. Now, the terms of use is important for a number of reasons, but one of the most important is the fact that there's an option there as you create this document for your website to take advantage of the DMCA safe harbor from liability. Now, you may not be aware of this, but the U.S. Copyright Act says that if you provide a blog or a forum on your website that allows visitors to post, which could be infringing material on your website, that you also could be an infringer unless you take advantage of the DMCA safe harbor. So there's an option there for that notice to be in your terms of use, and there's also a separate document consisting of the registration form that you need to file. There are also some other disclaimers, one involving testimonials. Most of us use or plan to use testimonials. There are important FTC regulations involving them, and we provide a document. So these basic documents are exactly what you need to get started with FTC compliance right now. Now, as a basic level member in FTC Guardian, secondly, you have the option to upgrade to the pro level membership, and I'd like to give you a quick description of the benefits of what that would be available to you as you upgrade to pro level membership. Now, the 8 documents that you see or you take advantage of in your basic level membership expand to, I believe it's a total of 86, 85 or 86 at my last count, documents, including, of course, the basic level, but additional documents that are supplemental to the basic documents. And one of the key ones is a privacy policy that we've just updated to provide the disclosures you need if you participate in targeted and retargeted ads. As you'll see in the training that we'll get involved in just a couple of minutes, there are some important FTC regulations, also ad regulations by Google and Facebook that require certain notices, certain disclosures, and this privacy policy in the supplemental group provides exactly what you need. But there are also additional documents that are in the pro level membership involving customer agreements, involving intellectual property agreements, involving promotion and marketing agreements through intermediaries such as affiliates, resellers, joint ventures, that sort of thing. But one important point to be made about all documents, whether they're in basic or pro level, and that is what they are not. They are not templates, simple fill in the blank, cookie cutter documents. They are documents that are highly customized through a technology known as rule-based document assembly, also known by the acronym RBDA. Now, this technology was developed by me years ago for use in my law practice. And by the way, these documents are what I use every day in my law practice, and I make them available to you as FTC member. But the thing I understand here is this. You are presented certain questions to answer. And sometimes the question you're being asked depends on the answer to a prior question. So there's a logic tree underneath. You'll be asked questions very similar to what I would do if you employed me as an attorney. I would ask you questions, you would answer, and then based on the answers, I would create a document. And that's exactly the way the process works with the FTC Guardian documents. The software asks you questions, you provide the answers, and there's assistance there for making the correct answer. And then at the end of the questionnaire, you hit submit. And at that point, the software goes to the database of thousands of clauses, pulls out the ones that are indicated by your answers to the questions, and then assembles a document on the fly, numbers the clauses appropriately, and all of this takes only about 5 seconds, spits out the document, which is a customized document, much better, much more better fit for your website and your business than a cookie cutter template would ever be. Now, so we have a pro membership that you do has many more documents. What really sets us apart is the training. And at the basic level, we have a collection of 3 to 5 minute videos, very easy by me, on topics that you need to understand for your everyday operation of your business. For example, you use testimonials, as I just mentioned. Well, there's a description of the rules and how to comply. Another area is outsourcing. We all do outsourcing, many of us to Fiverr.com for a graphic image that we use on Facebook posts, or a cover for our book, Kindle book, that sort of thing. So the Copyright Act provides that the default rules operate in favor of the outsourcer, not you, even though you pay for the work. And so unless you have a written agreement signed by the outsourcer stipulating magic words of work made for hire, then the outsourcer owns your work product. So these videos explain those rules, how the rules can be made to operate in your favor, and documents also back that up. But last, certainly not least, in terms of the training at the pro level, are live Google Hangouts twice a month on very specific topics, in most cases representing new developments so that you can stay up with current developments. It's not enough to just post documents on your website and then sort of forget about it. You need to understand the developments as they occur, and they're going to occur and continue to occur at a very rapid pace. And that's what the Hangouts are all about, a very specific, usually 20-minute presentation by me, and then we open the floor for live Q&A. So where in the world can you go and have the opportunity to ask an internet attorney full-time, which is what I am, questions about the topic that we've just discussed or something that seems to be remotely related to it twice a month? A great value and available to pro-level members. So we invite you to, as you use the benefits of the basic level membership, which is going to be your bonus, that you consider our invitation to upgrade to training that has tremendous value to help you operate your business in conformity with FTC regulations. Okay, so much for the introduction here in this video. Let's get to the training involving ad retargeting and targeted ads, which is really extremely important. And I'm going to go to the slides here that you see here. You see the title slide, top 3 killer mistakes to avoid. Let's go back to that title slide, top 3 killer mistakes to avoid with ad retargeting. So there's a housekeeping announcement here to begin with. This training, this information is presented for informational purposes only. It's not legal advice, and no attorney-client relationship is created. Now, we all know the cliche that you can learn from your mistakes and it's okay to make mistakes because they're learning experiences. And I agree that that's excellent advice, except when you're involved in, say, mistakes that result in failure to comply with FTC regulations. Generally speaking, it's true, but when you're dealing with FTC compliance, it's not, because a single mistake can change your life if you're sued by the FTC. So let's take a quick look at what part of the cover page of an FTC complaint in a lawsuit would look like. On the left side, this is taken from a clip from a page in a lawsuit, recent suit filed against a fairly small internet company called Apply Knowledge. You see Federal Trade Commission versus Apply Knowledge. What you don't see on the left side are The people who work there, they're also named. I'll mention that in just a minute. But on the right side, look at this. Temporary restraining order, asset freeze, appointment of a receiver. This business has been shut down. This is what you don't want to see with your name on it and your company name on it. Now, as I indicated a second ago, below the listing of the corporate defendant on the left side, there were individuals named. And it's important to understand that the FTC does not have to engage in what is known as piercing the corporate veil. You may have heard that term as it relates to run-of-the-mill general civil litigation, where a plaintiff has to jump through a lot of hoops in order to get through the entity, the corporation or LLC, to your personal assets, your bank account, your home, your car, that sort of thing. But with respect to the Federal Trade Commission, it's very simple. They just simply list your name under the entity name, and all they have to show is that you either were involved in creating the ads or you managed the people who were. And you've got personal liability, meaning that not only are your business assets at risk, but also your personal assets, your home, your car, your bank accounts, that sort of thing. So that's why being on the right side of FTC compliance is so critical. And here's a clip from one of the lawsuits about what the asset freeze actually looks like in black and white. And I'm asked this question a lot from clients and from other people where I speak, for example, on stage. And here it is. You can see it. Hereby temporarily restrained and enjoyed from transferring to dispersing spending, etc. All sorts of types of assets, including funds and accounts. You don't want to find yourself here. And for some reason, most online businesses, this is what really is probably the most scary thing of all. And again, you don't want to find yourself here. All right, so let's get to the killer mistakes. What are they for ad retargeting? Mistake number one, failure to properly disclose collection, use, and sharing of information for ad retargeting. Very significant here. And we've got a couple of cases, one involving a company known as Upromise in 2012. And in this case, the FTC's claim could be classified generally as involving affirmative misstatements, which is a fancy term, meaning that there were statements and assurances made in Upromise's privacy policy, but Upromise didn't follow through, didn't keep those promises. And by the way, the FTC views these things as not simple statements, but promises. And if you fail to keep them, it is a deceptive marketing practice. So that's what happened here. Upromise had a toolbar, which in the privacy policy was stated that it infrequently collected personal information. Turned out to be not true, and that Upromise would, quote, remove any personal information prior to transmission. Again, not true. So the FTC sued, and in the settlement, all the data, prospect data, databases, marketing databases were all destroyed. A second case also in 2012 involving Epic Marketplace. But the significance of this case is that the FTC claim was not based on failure to keep a promise. It was instead based on a lack of transparency, meaning that there was a failure by Epic Marketplace to simply disclose what they were doing relating to the tracking of browsing histories for purposes and this would also apply to ad retargeting. So you're not making a statement in black and white in your privacy policy, then failing to live up to it. You're just simply failing to affirmatively disclose and provide transparency for certain types of very sensitive activities, which of course ad retargeting and targeted ads would fall into. Again, the settlement involved the destruction of all the data collected. Now, in the failures to disclose what is required can get you into trouble at two levels. One would be at the platform level. For example, Google and Facebook each have disclosure requirements, and if you fail to make those disclosures, you get banned from the platforms. And then, of course, the second level would be the FTC compliance. You get sued if you fail to make the proper disclosures. And the early cases that we've just seen with the two cases we've looked at, the results are only data destruction of all the data they've acquired, their list, their customer lists, their all that stuff. But future cases, as we'll talk about in just a minute, are going to impose massive fines, which you definitely don't want to be involved in. So, killer mistake number 2, failure to disclose opt-out opportunities. So not only are you obligated to disclose how you collect this information for purposes of targeted and retargeted ads, you're also required to provide certain opportunities to opt out of this practice. Google requires a specific link. Facebook requires that you have a process where you remove the particular consumer from the Facebook custom audience, right? And then there are trade association websites, one by the Network Advertising Initiative website, NAI, and also the Digital Advertising Alliance website, DAA. They have web pages that allow opting out. And so links to those opt-out pages need to be provided in your privacy policy. And then finally, killer mistake number 3, this is important, failure to adapt to the rapid pace of legal developments for ad retargeting. Now, there's some really key facts you need to be aware of, and that is clearly retargeting has transformed monetization on the web. It is woven into the very fabric of the internet now, and it's just happened very, very rapidly. Why? Well, it's because retargeted and targeted ads convert very, very well. That's why. And if you're not involved in retargeting now, you will be soon, in my opinion, or you won't be competitive. A final fact is that the FTC regulators are going to continue to struggle with keeping up with the rapid pace of the growth of tracking tools and methodologies. The FTC is sort of behind the curve right now, and they're trying, there's so much development in terms of innovation in terms of tracking tools and methodologies that are used for ad retargeting. The FTC is trying to figure out how to keep up with all of this. And what you need to understand is the FTC is conflicted, because on the one hand, the FTC is the preeminent authority for consumer protection. And a lot of consumers are extremely concerned about retargeted ads. They view it as a privacy issue, right? So the FTC needs to regulate. However, the FTC also realizes that another segment, a significant segment of the population, likes the fact that they see ads that are targeted to their interests. So they've got to have a happy medium here in terms of the regulation. So they're going to struggle, but they're going to continue to regulate clearly. And there are going to be 2 levels or ways that regulation comes about. One is going to be bottom up, and as we'll see in just a minute, top down. So the classic examples of bottom up would be the 2 cases we've looked at here. And again, there's going to be a tsunami in my view. My prediction is from the bottom up in the very near future, and you're going to need a resource to keep up with this so that your privacy policy can be updated and stay in compliance with these regulations in order to continue to enjoy the benefits of retargeted ads. Then you have top down, and you might be aware, or if you're not, you might Google 2014 Data Broker Report FTC, or some collection of those words, and you will be able to download a PDF of this 2014 report. Now, the FTC until very recently was really not aware of data brokers at the top level of the retargeting ecosystem. These are companies that collect data from lower sources that essentially share data upstream. And then these brokers aggregate this data into massive data sets. And we're talking about clickstream data of consumers and all sorts of other types of data that indicates what they do on the web. And then they use data mining techniques to profile consumers, and then they sell this profile information back down to smaller companies such as you to use in retargeted ads. And the FTC is very concerned about all this. It's not regulated at all, so there's going to be some regulation coming down, but it's going to percolate down to you, trickle down to you at the lower level. So this is another reason you need a way to stay up, to keep up with these developments. So my recommendation here is, if you're going to enjoy the benefits of retargeted ads, which are immense and really important, then you need to either employ an experienced online advertising attorney, or the next best option for you is an upgrade from the basic level membership, which you're going to receive as a bonus, to the FTC Guardian Pro level membership. So that's all from me from now about the bonus that you're going to receive as a member of the Engage Pro level and up membership from Kim. Also, how you can upgrade that basic level membership to the pro level membership and all of its training related benefits. And then finally, the information which I think should be very helpful to you as you either engage in retargeting, the training we've just covered, or plan to do so in the near future. So that's all for now. Thanks for watching.